Hello, everyone, and welcome. Today, we're going to get right into the nuts and bolts of the Indian judiciary. We're going to take a look at its structure, its incredible power, and all the constitutional safeguards that are in place to protect it. By the end of this, you'll have a really clear blueprint of one of India's most vital institutions. So, here's our roadmap. We're going to start with the big picture, the whole judicial pyramid. Then we'll zoom in on each level, starting at the very top with the Supreme Court, then moving to the high courts in the states, and then down to the subordinate judiciary, which is really the foundation of it all. And to wrap things up, we'll look at the one thing that holds the entire structure together, judicial independence. All right, let's lay the groundwork. The first thing we really have to grasp is that India made a very deliberate choice when designing its court system. It's not like some other federal countries that have, separate court systems for the center and the states. No, India's constitution sets up something totally different. And that choice was a unified judicial system. The best way to think about it is like one single massive pyramid of courts that covers the entire country. And what's so important about this structure is that it's designed to enforce both central and state laws. This makes sure that a law is interpreted the same way, whether you're in Kerala or Kashmir. It's absolutely key for holding the country together legally. So as you can see, this pyramid has three really clear tiers. At the very, very top, you've got the Supreme Court. It has the final say on everything. Then in the middle, we have the high courts, which are the main courts for each state. And down at the bottom, at the base, is this huge network of subordinate courts. That's where the legal journey begins for most Indians. So let's start our climb at the very top. So here we are, at the summit, the Supreme Court of India. And let me tell you, this isn't just the highest court in the country. It's considered the ultimate guardian of the Constitution itself. You could even call it the final sentinel of our democracy. Now, its power really comes from two main functions. First, it's the final court of appeal. What does that mean? It means when the Supreme Court makes a decision, every other court in the country has to follow it. Period. But second, and you could argue this is its most important job, it is the ultimate interpreter of the Constitution. It makes sure that every single law and every government action is in line with our nation's founding principles. So, how does someone become a judge at the highest court? Well, Article 124 lays out the whole process. The president makes the official appointment, but the real recommendation comes from what's known as the Collegium. That's a body made up of the Chief Justice of India and the four most senior judges of the Supreme Court. The Constitution is very clear that the Chief Justice must be consulted, which is a key role meant to protect the judiciary from political influence. And once they're appointed, these judges serve until they turn 65. The real muscle of the Supreme Court, though, lies in its huge and varied jurisdiction. And jurisdiction, that's just a legal term for the authority a court has to hear and decide a case. So let's break down the main types. First up, we've got what's called original jurisdiction under Article 131. This is the power to hear a case right from the start. For the very first time, it's not an appeal. This power is exclusive to the Supreme Court, and it mostly deals with really high-level disputes. For instance, a conflict between the government of India and, say, the state of Tamil Nadu. Next, and this one is so important, is writ jurisdiction under Article 32. This is an incredibly powerful tool that lets any citizen go straight to the Supreme Court if they believe their fundamental rights have been violated. The court can then issue what are called writs. These are powerful judicial orders to set things right. And you don't have to take my word for how important this is. Dr. B.R. Ambedkar, the main architect of our Constitution, literally called Article 32 the very heart and soul of the Constitution. And his logic was simple. What's the point of having fundamental rights if you have no way to actually enforce them? And then, of course, there's its appellate jurisdiction. It is the highest court, after all. So it's the final stop for appeals from lower courts. And this power covers basically the entire legal world, from civil cases under Article 133 to criminal cases under Article 134, and even the most critical cases that involve deep questions of constitutional law, which fall under Article 132. Okay, so let's climb down from the peak of our pyramid to the next crucial level, the high courts. These are the highest courts within each state, and they really act as the pillars of the justice system at the regional level. Now, this is interesting. Take a look at the difference in how judges are appointed here. For a high court judge, Article 217 says there needs to be a much wider consultation. The president still makes the appointment, yes, but they have to consult not just the Chief Justice of India, but also the governor of that state and the Chief Justice of that specific high court. It's a way of weaving state-level perspectives into the whole process. The writ jurisdiction is another fascinating contrast. You see, going to the Supreme Court under Article 32 is a fundamental right in and of itself. But the High Court's power to issue writs under Article 226 is discretionary. But, and here's the twist, the High Court's power is actually wider. It can issue writs not just for fundamental rights, but for any other purpose. This gives it a massive mandate to correct injustices within its territory.
So, we've talked about the top courts, but let's be realistic. For the average person, the legal system doesn't start at the Supreme Court or even the High Court. So the real question is, where does the journey for justice begin for most citizens?
And that question brings us right to the foundation of the entire structure, the subordinate judiciary. This is where the vast, vast majority of legal cases in India are heard first. This is truly justice at the grassroots level. It's all governed by Articles 233 to 237, and it includes things like the district courts and other lower courts where most cases begin. And notice the structure here. District judges are appointed by the state governor, but always in consultation with the High Court. And what's really crucial is that Article 235 gives the High Court complete administrative control. This basically acts as a shield to protect these lower courts from local political pressures. Okay, so we've built our pyramid, we've seen all the levels, but what keeps the whole thing from being pushed around by politics or powerful interests? Well, that brings us to the single most important idea holding it all together: judicial independence. This isn't just some fancy idea. It's a core structural principle of our Constitution. The whole system is designed with one goal in mind: to make sure a judge can make a ruling against the most powerful person in the country without any fear or any favor. That's what it's all about. The Constitution doesn't just hope for independence, it builds a fortress around it. The collegium system for appointments, that's like the gatekeeper meant to limit political influence. Once judges are in, they have security of tenure. It's incredibly hard to remove them. Then you have the power of judicial review, which lets them strike down unconstitutional laws. Article 50 digs a moat, separating the judiciary from the executive. And finally, judges can't practice law after they retire, which gets rid of potential conflicts of interest. Every single one of these is a constitutional brick in that fortress wall. And this brings us to our final and very critical question. We've seen how the collegium system is designed to defend judicial independence, but this leads to a huge debate around judicial accountability. If impartiality is what we want, is a system where judges appoint other judges really the most transparent and accountable path to justice for everyone? It's a tough question with no easy answers, and definitely one worth thinking about. Thanks for joining me today.